The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, March 23rd, 2016 are currently trading with gold at $1,223.93 an ounce, silver $15.28 an ounce, Texas crude $41.45 a barrel, and Bitcoin is currently sitting at about 417 U.S. currency. Today in history, the year 1775, Patrick Henry proclaims, "Give me liberty or give me death," in a speech in favor of Virginian troops joining the U.S. Revolutionary War. The infamous slogan of American rebels, "Give me liberty or give me death," was first said today in history. In recent news, an independent panel investigating the Flint water crisis blamed Governor Rick Snyder's office directly, concluding that incompetent state employees in charge of supervising water quality, including state-appointed emergency managers, ignored a list of growing problems with the city water supply and negligently ignored signs of lead contamination. The 116-page report had blame for every level of government, from local Flint officials to the Federal Environmental Protection Agency, but blamed the Michigan Department of Environmental Quality, the state agency responsible for monitoring Flint's water supply, as primarily responsible for the water contamination in Flint. The report said that the Flint water crisis is a story of government failure, intransigence, unpreparedness, delay, inaction, and environmental injustice. Turkey's President Recep Tayyip Erdogan said today that Belgian law enforcement and anti-terror departments ignored warnings last June that one of the brothers suspected of blowing himself up in the terror attacks there on Tuesday was a terrorist. Ibrahim El Bakroui, suspected of being the bomber who blew himself up at the Zaventem airport, killing at least 11, was stopped crossing into Turkey from Syria 9 months ago, when Turkish officials said that they apparently told anti-terror agencies in Brussels of his involvement with ISIS, the group who claimed responsibility in Tuesday's attacks. A Turkish official stated Dutch authorities allowed Bakroui to go free because they were unable to establish any ties to terrorism or ISIS. The Israeli newspaper Haaretz reported today that Belgian security service, as well as other Western intelligence agencies, had advanced and precise intelligence of the pending terror attacks prior to them. The newspaper said government agencies had specific warning that the attacks were coming soon and would take place at the airport and in the subway system, though it is not clear how exactly said agencies were warned of the attacks in advance. This was Rick Brody with your lowdown for March 23rd, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? You chuck it on that one, you chuck it on this one, you chuck it on your mother and you chuck it on your father, you chuck it on your brother and you chuck it on your sister, you chuck it on that one and you chuck it on me. Bad boys, what you gonna do? What you gonna do when they come for you?
Okay, howdy. This is Randy Kelton, Deborah Stevens, Root of Law Radio on this Thursday, the 24th day of March, 2016. And I'm going to turn the phones on. We'll keep having them on all night. I have a couple of people I was hoping would call in early. Phone lines are on, 512-646-1984. And I want to start out with a little good news. We have been working up here in the Dallas-Fort Worth area to get the access to the grand jury pried open. I just had a very interesting meeting with my local prosecuting attorney. Takes a little background to understand what's going on here. A year ago in January, I went to the hearing where the district judge was impaneling a grand jury. Prior to going there, I gave notice to the district court and to the district attorney that I would be appearing for the purpose of challenging the grand jury pool. Under Texas Code of Criminal Procedure 19.27, anyone can challenge the grand jury pool. And in doing that, and the thing about it is, I tripped over my tongue. Anyone can challenge the grand jury pool. Prior to impaneling of the grand jury, well, this particular district judge happens to hate me. The other district judge, the county judge doesn't like me, but he doesn't hate me. This judge hates me. So after he impaneled the grand jury, I asked him to reconvene the grand jury pool, disband the grand jury that he had selected, and give me opportunity to challenge the pool. Well, he got a little huffy and at one point threatened to have me arrested. And a bailiff came over and put his hand on my arm. So a bailiff, while prominently displaying a deadly weapon, committed an offensive touching while prominently displaying a deadly weapon in a manner which was intended to be threatening, while acting under the color or pretense of an official capacity at the direction of the district judge. I considered that, according to code, an act of first-degree felony aggravated assault. Well, I'm sure they didn't consider it that way, but that's okay. So I went to the Texas Rangers because Texas Rangers were put in place last year to take the place of the public integrity unit for the district attorney's office. I know Tarrant County had one, Dallas County, all of the bigger jurisdictions had a public integrity unit. And I had argued that a public integrity unit by the part of a district attorney was a conspiracy to breach Article 2.03 Code of Criminal Procedure. 2.03 directs prosecuting attorney, when he's made known that a crime has been committed by a public official, he must reduce the complaint to an information and submit it to the grand jury. It takes away any discretion that he may have. So when the Texas Rangers were put in place, they were directed by statute to develop a set of protocols by September of last year. And they did that. And the protocols required the Texas Ranger to request permission from the prosecuting attorney before investigating a public official. That was problematic because prior to this, Texas Rangers could not investigate a public official, neither could they take a complaint against a public official without the express permission of the director of the Department of Public Safety himself. It rendered everything concerning public officials purely political. The legislature passed legislation to eliminate that nonsense. But the higher-ups in the Department of Public Safety established protocols that reestablished the status quo. So my position was that a Texas Ranger, if he deals with the prosecuting attorney, and the statute requires him to work with the prosecuting attorney, if he asks the prosecuting attorney to exercise discretion as to investigating a public official, that's a conspiracy to breach Article 2.03. And I needed that question brought to the courts. So I gave a criminal complaint to the Texas Ranger against the district judge. And he did exactly what he said he would do and gave it to the prosecuting attorney. And the prosecuting attorney took no action because I already talked to the prosecuting attorney about it and gave him my concern and indicated what I was prepared to do. And we had a meeting this last week, and I indicated to him that there were some fights I wanted to have, and one of which was discretion. He said he believed that he had discretion. I said, I understand that, and I believe that you don't. And that's a fight I want to have, but not with you. I'll take that fight on elsewhere. There's about half a dozen fights in here I could have, but I want to avoid all those. So rather than me engage you in this process, I'm going to make an offer. I'll come down and take my complaints and give them to the bailiff with instructions to take my complaints and give notice to the foreman of the grand jury that I have these complaints. And I'll hand him a stack of 12 folders, actually 13 folders, with instructions that he give them to the foreman of the grand jury. There's a 13th folder for him to look at to make sure that there's not a fatal error in my presentation, to make sure that it is sufficient for presenting to the grand jury, but not for the purpose of discretion, deciding whether or not he wants to submit it. And he got that, and he agreed to that. So kind of got I requested that he instruct the bailiff not to do anything stupid. But this is what I was going to do, and I wanted to make sure that the bailiff understood this and didn't try to exercise some discretion of his own. And he said he would instruct the bailiff. So we got the door open to the grand jury here in Wise County as well as Tarrant County. And the next one I'll be going after is Dallas County. So from this perspective, we did really good. So I'm really pleased with how that came out. Okay, we have 2 calls already. I've got 2 calls, and Jim was first, but I'm going to take Jeff first because Jeff is generally pretty quick. And then we're going to go to Jim. Jim's going to take a little longer. Hello, Jeff. What do you have for us today?
Well, hey, Randy, thanks for having me on.
You're welcome. And what is happening in your federal case? For those who've been following, Jim was prosecuted for bringing a rifle onto a college campus when he didn't believe he was on a college campus. The property he owned was separated from the campus, but they prosecuted him anyway. He's been fighting them. Now you have filed a federal suit, and where are we?
Okay, well, one question is for one federal suit, and another's for the other, and I don't think they'll crisscross. I put in a standing objection against a magistrate. And because I filed in forma pauperis, but I put in a standing objection to have a real judge, lo and behold, I now have a conference April 14th with a magistrate. It's by telephone. When I get on the telephone, do I need to, first thing, object to having this person as a magistrate and hang up on them and refuse to talk?
No, do not hang up. Do not refuse to talk. Raise your objection to the magistrate and then continue. What you're doing in the trial court is setting the record for appeal. And in the overall scheme of things, I don't know that a magistrate is such a terribly bad idea. I guess that's going to go to every magistrate. Because the magistrate simply gives a recommendation to the district judge, and the district judge will make his determination. Now, they generally follow what the magistrate says. But if the magistrate does anything you don't like, you already have your standing objection before the court, and it will have the effect of negating anything that the magistrate does.
Okay. Now, this is the same court, this is the one in Mississippi, that we were talking about doing a non-suit so I could move it to Arkansas where I live. Yes. However, they never answered that motion. They just came up with a telephone conference. So do I need to move for a non-suit or change of venue during the telephone?
Have you filed a notice of non-suit?
No, I filed a motion to change venue. The game plan was to file a motion to change venue. If they did not do it, then non-suit it and then reopen it in Arkansas.
Okay, then request that at the hearing, notice the magistrate that you have a motion for change of venue before the court, and you object to this hearing prior to a hearing on the change of venue.
Okay. Do 2 objections. Okay.
Yeah, and then you've got your position before the court, and then go ahead and have the hearing, because I take it this is a scheduling hearing?
Probably so. It didn't exactly say, but it did say that the parties are going to...
If it says nothing else, if there's nothing saying that this is for some other purpose, the first hearing that's had is normally a scheduling hearing. It is normally not done with a magistrate. It normally isn't a scheduling hearing. It's a scheduling conference. And that's just you and the other party. This is unusual to have a judge in the middle. Hang on, Randy Kelton, Rule of Law Radio. We'll be right back.
You are listening to the Logos Radio Network. The LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio. I'm sorry, Randy Kelton and Deborah Stevens, Rule of Law Radio. Deborah Stevens is lurking there in the background to make sure I don't run off the cliff. We are talking to Jeff in Mississippi. Okay, Jeff, go ahead.
Okay, last one. I have been listening to Rick Schramm, and he seems to be pretty good, but he talks really fast. He did predict that when you get into one of these suits, the lawyers have a tendency to 12b6 over and over and over, and the judge will play tennis going back and forth because it makes them money, but they're just doing it to drag the case along. And he said, and I'm not trying to pit him against anybody else, but he said that when they do that their motion to 12b6 has to have an affidavit, and it has to have truthful statements. And if they're just playing around and calling you names and being vexatious and scandalous, that you can then bring sanctions against them to stop the little tennis game, for one thing, and to go ahead and try to bring charges and to move for summary judgment on the pleadings. What do you think about that? Because they have already done that. I now have a second 12b6 response that's no different than the first. It's just a little bit of name calling.
I think Rick is dead on.
Okay.
Absolutely. Now, you can't bring sanctions. What you can do is move for sanction and ask the court to bring sanctions. And that's kind of why I suggested that in this hearing that you merely give them notice of your objection to the magistrate, but don't refuse to participate in the hearing. But there's a good chance that the certain feller doesn't agree with me, or at least has a comment on this subject. We have Mr. Jeff Sedgwick on the line.
Yeah.
Jeff, did you want to chime in?
I'm here.
Okay. Did you want to chime in on this subject?
Oh, I did.
Somehow I got that impression.
I have a litany of questions for Jeff in Mississippi.
Okay.
Did your cover sheet request a trial by jury?
Yes. Well, no, I'm sorry. My complaint did at the end where the prayer is and my signature.
Did the cover sheet request it?
No. I didn't
Big
see
mistake.
the cover sheet on my Okay.
Big mistake. Don't do that again.
All right.
And the reason why is you can always ask for it and then retire it. But if you don't ask for it up front, you can't get it.
Okay.
And you need to get it on the cover sheet. How many 12b6 motions have they filed?
So far, 2, but they've come in a 10-day period.
Stop.
So he's shooting.
Has the first one been ruled on?
No.
So the second one hasn't been ruled on either?
No, it just says renewed 12b6. As soon as I sent my answer in and my amended complaint, I fired one back.
Right.
So wait a minute, you said it said renewed?
Yes, it says renewed 12b6 on it, and it's got a bunch of silly stuff. You can tell the guy's just calling.
Okay, hold on. Does it address different material issues than the first?
No, not really. It just says that the plaintiff doesn't have.
But no, wait a minute, Jeff. Either it does or it doesn't. It's no, not really.
Oh, I'm sorry. No, it is different.
Okay.
Is it different in a material sense, or is it merely superficially different?
It's superficially different because both of them are just superficial.
What is the basis for the 12b6?
That they have qualified immunity, and I have felt
who has qualified immunity?
The officers.
You sued a university.
Police officers?
Well, they're campus officers. Without getting educated,
And have you looked up qualified immunity in their situation?
Oh, yeah.
And do they?
No, absolutely not. They committed fraud. And
so you got to no. Take that daggone word and you flush it down the gurgler. Never to be heard from or seen again.
Uh-huh.
It's
false and misleading.
Okay.
Fraud should never be used unless it's a special circumstance where you have the elements and you're trying to bypass qualified immunity.
Okay.
So here's what the truth is on that fraud. It requires that you prove intent, and you can't prove what was in somebody's mind. So as I said, you take that word, you throw it in the gurgler, and you pull the lever, and that word is never to be seen or heard from again. It's false and misleading, and that you can prove.
Okay.
Okay? Now, who is the actual judge in your case?
It is a circuit judge. I don't remember their name. It is the circuit judge.
Okay, that's fine.
District judge.
So he has assigned the grunt work to a magistrate. Typical activity on the part of the federal court. The judges have the magistrates do the grunt work. Don't panic. Okay?
Uh-huh.
They are an excellent source of case law. And if they decide, or if the magistrate decides that your pleading is not sufficient to go forward on, he's going to say so, and he's going to say why. And he's also going to say what is needed. Okay?
Sorry.
And if they do dismiss you, since you are pro se, they have to give you leave and time to amend.
Unless it is Judge McBride in the Northern District in Fort Worth, and if you are a pro se, he will dismiss with prejudice, out of hand, without regard to the right of things of the rule of law.
But that you take up with the Fifth Circuit.
That I take up with the Texas grand jury.
So,
I'm looking forward to it.
That's the way they work.
Okay.
So pull your claws back in and relax and have another beer and stay on point.
Okay.
The magistrate is not necessarily your enemy. And I didn't give you a guarantee that he was not your enemy, but he is not necessarily your enemy. And
Yes,
Mississippi, let me see, Mississippi. That's also in the Fifth Circuit.
Yeah.
Yeah, yes.
Okay.
And
I have a little trouble keeping it straight as to where the line of demarcation is. Alabama's in the 11th.
right, Louisiana and Texas are fifth.
Yeah. And there's been some neat stuff coming out of the 5th, 6th, and the 11th circuits as of late. And a lot of it has been coming out of pro se actions. So don't get into panic. Just be calm, cool, and collected. No emotions.
This is how Harmon Taylor addresses the federal judges and magistrates.
I can't
He
hear you, Randy.
considers everything they do as teaching. They're always instructing both parties on how to move their case along properly. And his position is pay attention to what they tell you. They will instruct you.
Okay.
Have you read current?
All these 12 pieces. Let's say
Translate versus Bagliaro?
respond.
Wait a minute. Hold
Say
on.
again, sir?
One at a time. We got about 44 seconds. Jeff?
All right.
Wait a minute.
There are two
Jeff,
cases.
Jeff,
There's
Jeff
a number of
Maryland.
cases on the Supreme Court.
Okay, sorry, I messed that up, Jeff. We got two Jeffs here, and I'm confusing the two. Hang on.
Which Jeff
We're about to
are
go to
you
break. We'll pick this up on the other side. This is Randy Felton, Deborah Stevens, Rule of Law Radio. Our call-in number, 512-646-1984. Jim, hang on. We'll get to you. I took Jeff because I thought he'd be a little quicker. He's a little more complex than usual. But we'll finish up with him shortly. We'll get to you on the other side. We'll be right back.
Are you prepared for your billboard moment? If you post on social network sites, you might be heading for the spotlight in a bad way. I'm Dr. Catherine Albrecht, and I'll tell you more in just a moment.
Your search engine is watching you, recording all your searches and creating a massive database of your personal information. That's creepy, but it doesn't have to be that way. Startpage.com is the world's most private search engine. Startpage doesn't store your IP address, make a record of your searches, or use tracking cookies, and they're third-party certified. If you don't like Big Brother spying on you, start over with Startpage. Great search results and total privacy. Startpage.com, the world's most private search engine.
What do an Israeli soldier, a Massachusetts high school teacher, and an Oregon mayor have in common? They're just a few folks whose tweets, Facebook wall posts, and other social networking faux pas have come back to haunt them. The soldier's post about his unit's planned raid stopped the army. The teacher lost her job for referring to students as germ bags, and the mayor was stripped of her office for posing in her undies. So think before you post. If you wouldn't want it shouted from the rooftops, downloaded by an enemy, published in the employee newsletter, or emblazoned on a billboard by a busy street, don't post it on the internet. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Yeah, Mr. Officer, you're taking the law in your hand. Won't you follow the law of the land? I don't understand. Would service to protect and serve. Not beat and abuse.
Okay, we are back. Randy Kelton, Rule of Law Radio. Randy Kelton, Deborah Stevens, Rule of Law Radio, here with Jeff in Maryland, and we're talking to Jeff in Mississippi. And I had a question on the second 12B6. Jeff, can I file a second 12B6 while one 12B6 is before the court? And if I can, is the second considered an amended?
Well, I'm not sure that the second one is actually a second one. They could file a second one and say basically that the first one that there was a mistake and they're correcting the mistake and say it's corrected. I'm not sure what renewed has to do anything with it, but you're going to have to take a look at Black's Law Dictionary.
Yeah, they didn't call it a nuns pro tunc.
Somewhere in the Code of Civil Procedure.
Nuns pro tunc, they could file something nuns pro tunc, and that says, well, we made a typo or a minor non-material error. And that's why I was asking about material differences. But they didn't call it a nuns pro tunc. They called it what did they call it, an updated?
Just a renew.
Well, usually it's
just a waste of time.
What was that?
They're just throwing tennis balls at me. So how can I cut them off?
Well, that's way too general for us to make the specific determination we're trying to get to actually what the second 12B6 was about. Was it essentially the same things with just some nitpicking add to it that didn't really change the material claims?
Yeah, one of them said that I don't have a liberty interest in the school and that the school didn't take my constitutional rights away and that they still have immunity, qualified immunity, which is just a repeat. And then,
wait a minute, hold on. We're talking about the difference between the two. Did the first one make those claims?
And the second one does too.
Okay, so this sounds like a rehash of the first. So, Jeff, what do you think? Would that?
I mean, I'm not very good on the law, but even when I read it, it looks like kids are fighting over jacks and balls. It's just silliness.
Well, I would suggest that you view it that way.
Okay.
Yeah. This is a serious argument, believe it or not.
Yeah.
Okay.
So how do I cut these guys? Do they have to have an affidavit, or if they're making malicious, false comments or something? There's some way that I can stop them and bring sanctions against them.
Well, you answer it.
Okay, but then they're just going to answer in 2 weeks with another silly thing, and then
no, you can't do that, Jeff.
Jeff, that's the way the game goes.
Okay.
And if you're unwilling to play the game, get out.
Okay.
Answer the second one and ask for sanctions.
They got the attorneys have got a job to do, and that's basically to get these guys off. And you've got a job, from what I can determine, to do, and that's to vindicate your rights.
Okay. Well,
and you have a right to be left alone, and it was a peaceful use of your property without torturous interference.
Okay.
What this case is about, Jeff, is he applied to college for entrance to the college, and they denied him access to the college.
I don't think I understand, Randy.
Will you explain that to Mississippi?
Well, they denied me entrance because of the gun charge, but they didn't give me reason why, so they just threw me out. And so I'm suing them over lack of due process, that I wasn't given a hearing or any kind of transcripts or written notice, which I wasn't.
Okay.
I was just tossed out like the mafia throws somebody out and then beats them up and throws them in an alley. That's basically what happened with my admissions process.
Well, I got a couple of questions for you. Did they refund all your money?
Oh, I never paid.
Okay. And is this the only school you can get into?
No, it's a school where I live. So
it doesn't answer the question.
I could move off and go to another college.
Okay. So even if you win, you still really want to go there?
Well, yeah, I want to. I'm almost done, so I just want to finish up and start work.
Okay. How many credit hours you got left?
Okay, just real quick, back on what Randy was talking about, the amended complaint and then ask for sanctions. Is that a good way to go?
Why?
Well, I think we're going to start playing volleyball with these guys, and I think that's what they want. So I want to get off the merry-go-round and move it along.
Okay.
Okay, Jeff, Maryland, whether or not he could go somewhere else, if this college receives any federal funds, he has a right to go here.
Well,
he could go to a college in Hawaii.
I'm not debating that, Randy. My question basically is, does he really want to go there after the way in which they have treated him?
Well, he's not happy with the
That's
way
all
he's
I was
treated him,
asking.
and he's trying to fix what's wrong, to give them reason not to pull this crapola on the next guy.
But see, these guys are going to respond with a 12B6 another 10 times. I can already see this happening over silly stuff, and it's just to keep me on the hamster wheel. So I'm wanting to get off the hamster wheel.
That's abusive. That you can move for sanctions on. 2 of them, you're not going to get anywhere with that.
Okay.
See,
But that's okay, because when you file for sanctions, you should also bar grieve them.
Okay.
I think
easily do that.
I think you want to take a look at the Civil Rule Procedure 15.
Got it. That's amended complaints.
No. I think it's 15. Whenever they, file a motion, 12B6 motion, you have a right to file an amended complaint without leave of court or consulting with the other side.
Yes.
And I think it's Rule 15.
Supplemental pleadings.
1B1?
Amending as a matter of course. A party may amend its pleading as a matter of course within 21 days after serving it, or if the pleading is one to which a responsive pleading is required. 21 days of service of a responsive pleading or 21 days after service of a motion under Rule 12B6, whichever is earlier. Was this done within 21 days?
Yes, I've already done that, and within 10 days, they've already hit me back with another 12B6. So I don't want that to go on another 10 times.
No, wait. You didn't answer my question.
Oh.
Did they file the second 12B6 within 21 days of your receiving service of the first?
Yes.
Okay, then they're good. They're within the rules.
And I think that's what's going to happen. I think it's going to happen another 10 or 20 times.
They got
It's
one.
not going to happen another 10 or 20 times. The court won't allow it. Give me a break.
That's what
The 21 days are
I
up.
wanted to know.
Next time they got to ask permission.
Okay, that's what I wanted to know. Yeah, I want to get off the merry-go-round. Okay, so I can send in my answer to them or my amended complaint again.
And the door closes on an amended complaint without leave.
Okay, so I can type up another amended complaint.
Wait a minute.
I'm sorry, my bad. I said complaint. My bad. I said amended complaint. I should have said amended 12B6.
Okay, I have filed one amended complaint in my response to their 12B6. They shot back another 12B6 to me within 10 days.
Okay, your amended complaint opened the door for them to file another answer because your amended complaint took the place of the original complaint.
Okay, that's what I want to know. So what do I do from there?
Make sure everything you want is in that amended because the original doesn't count at all.
Mm-hmm.
Hang on. Going to break. Be right back.
Not wage any battle, would your purpose has be done? Such a sentiment of soldier, a warrior of love, scuffling to keep the peace. All it's taking is a misunderstanding. If somebody calls the police, watching the spotlight, watching the spotlight, watching the spotlight.
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio. We're having a little technical difficulty. We lost Jeff from Maryland. And Jeff in Mississippi, I think we pretty well have yours answered. Is that correct? Hold on. I've got to unmute you.
I now have a second 12B6 sitting on my desk, which means that it's my turn to hit the tennis ball back to them. Do I want to send another amended complaint?
No, do not send another amended complaint. Just answer the 12B6.
Just answer it. Okay. Which is a normal caption, and then it says answer to defendants 12B6. And
yes.
And then do I have to have that notarized? I have to put an affidavit on there?
If you include statements of material fact that are not already in your complaint, yes. Otherwise, if you're just answering their assertions, no.
No, okay, so just answer.
Yes.
Just put answer and then just mail it back to them, or file it in the court, I mean.
Exactly.
Got it. Okay. I will do that, and then I'll call you next week and tell you how that went.
Okay, wonderful. Thank you, Jeff.
Thank you. All right.
Okay, now we're going to go to Jim in Texas. Hello, Jim. Sorry to make you wait so long. Generally, Jeff's a lot quicker than that.
Not the only person with problems. No big deal. No big deal. How are you this evening?
I am good. Okay, to start with, give us a brief synopsis of the case. In the synopsis, no argument as to what's right or wrong. Just kind of give us a timeline of what occurred.
Well, in August, my wife got pulled over and for riding on a brake, and then she ended up getting drug out of her car and arrested for driving with a license invalid. December, they had a scheduling notice. The end of December, there was a plea negotiation. She tried to ask about getting a fair hearing, and they flipped her off, and it was continued in a room in secret, and we recorded the attorney that the court appointed for her, and he threatened her several ways and told her that, anyway, he threatened her, and we recorded the whole thing, and if we didn't do what he said, then she was going to jail. And then never got to plea, got a memo docket in January. Pre-trial was in February. Tried to get in there again and talk to him. Wouldn't tell us anything. Still wouldn't give us any information on the case except for a couple of little things that they had in the clerk's office. She coming up here Monday went into for court, and they basically said she couldn't say anything at all. They wouldn't even let her use her insurance as proof that she had financial responsibility, and basically just put her in jail for 90 days for trying to stand up for her rights. And then, kind of odd when they looked at.
Yeah, you said they pulled her over for riding her brakes?
Yes, sir. That's what he said.
What was the statute that he cited?
We haven't found out. They refused to give us anything. They even gave us some kind of a motion in court. They finally the court finally pleaded for her not guilty when she brought it up after the trial had started in front of the jury.
Okay. At this hearing, what was she charged with that got her 90 days?
Driving while licensed invalid with prior convictions and without having financial responsibility, which she did have.
Did they convict her of driving without financial responsibility?
No, she stood up at the Senate thing and pointed at the judge and basically told him that he had an obligation to stand up for her rights, and he wasn't doing it, and because he wouldn't even take her insurance, and then that's when he took the insurance right then.
Okay, that wasn't okay. They took the insurance at that point and did not convict her of the insurance, right? Wait a minute.
That I know of.
Hold on. What court was this in?
County Court.
County Court.
County Court at Law Number 1, Parker County, Texas.
Did she already have a hearing on the insurance issue in the municipal or JP court?
No, sir.
Was the insurance issue before this court?
Yes, sir. She's had the same insurance policy for...
No, that wasn't my question.
Oh.
Okay, listen carefully. What was before this court? The reason I'm asking this question is no insurance is a Class C misdemeanor. The county court does not have original jurisdiction. If she was given a citation by a municipal police officer, the municipal judge would have original jurisdiction. If a county sheriff's deputy, it would be justice of the peace. So I'm wondering how a insurance issue got before a county judge.
I don't know. The insurance that she had with her was actually current now, not current then.
Okay.
We never even looked at it.
Are you certain that this hearing included the insurance issue?
That's what he said. He said the paperwork says driving while licensed and valid with previous convictions and without proof of financial responsibility. He said it was driving while license suspended with no proof of financial responsibility. And they used the financial responsibility against her to get her convicted, apparently. But they wouldn't let her use anything.
Okay, that will be interesting. How many prior convictions for driving while license invalid did she have?
They said that she had 3, but she said that she doesn't know of but 2, or 1 in February of last year that I know of is the only one I know of.
So you only know of 1. She admits to 2, and they're claiming 3.
Yeah, well, they tried to claim 4, but they said they only had proof of 3, but nobody's seen proof of. I mean, they would use the law. They used the transportation code against her, and she tried to use the transportation code, and it turned into a scofflaw, and everything ran through the prosecutor. The judge said she had every piece of evidence or anything she wanted to do with the prosecutor, not him.
Wait a minute. Hold on.
I would say the prosecutor.
Hold on. You're using pronouns. She said everything had to go through him. Back up, redo that with proper names so I know who's saying what to who.
Jordan, my wife, said that Judge Buckner told her that anytime that she wanted a piece of evidence or to ask the officer or any...
Did I lose you, Jim? Hello, Jim. It sounds like it seems we might have lost Jim here. Now, this is the reason I put Jim second, because I knew this would be a little bit complex and would take a while to get sorted out. So, it appears that Jim dropped. You'll probably call right back in. But Judge Buckner, oh, that's wonderful. I have had a run-in with Judge Buckner once before, and that one was funny. We had someone from Waco being held on exactly the same charge and multiple convictions for driving while license invalid. And I wrote him up a habeas corpus, and he filed it in the court. I'm sorry. He filed one that he wrote up. I wrote him up one, but he didn't file mine. He filed his. And I went to the court because he said they didn't hear it, and brought a copy of the habeas, and then looked in the record, and I found a copy of the habeas in the record. And I asked the clerk for a return on the habeas, and they couldn't find it. I'll get to this later if we have time, but Judge Buckner was the judge in the case. And after I jerked him around a while, they got this guy out of their jail really, really fast. Hang on. Okay, going back to Jim in Texas. Sorry, Jim, your call dropped there.
My fault, apparently. Where did you lose me?
Okay, she had, according to the prosecution, 2 priors. Were the 2 priors brought up in the evidence phase of the trial, or were they brought up in the punishment phase?
Honestly, I didn't. Can you say that one more time? I want to make sure I understood that perfect.
Prior convictions go to an enhanced charge. Hang on just a second.
Yes, sir. They were during the courtroom proceedings when they brought it up. The prosecution, I was in the vehicle, and I've been trying to get charges against the officer for myself personally. They won't talk to me, but I was in the vehicle. The prosecution said that I was their witness. They invoked whatever it is where the witnesses can't see the testimony.
Yeah, they invoked the rule of witnesses.
Yes, sir.
So you couldn't observe. Did you have anyone in the courtroom who could observe?
Just my wife, and one of the bailiffs was helping us a lot.
Okay, bailiffs don't count because they will screw you big time. Okay, next thing you need to do is go down and request a transcript of the case hearing.
Yes, sir.
And what I'll do is I'll come down there next week and muck around a little bit and might get them to want to get her out of jail. I've had some experience with Judge Buckner. I was telling that while you were off. We're about to go to break here. I'll pick this up on the other side. But before you do anything, now you back up and start sharpshooting them for evidence. And when we come back on the other side, I will show you how to do that. This is Randy Kelton, Real Law Radio. Our call-in number, 512-646-1984. Give us a call while we're on break. It's a good time to check Logos Radio Network and check out our sponsors and help us keep this radio show on the air. We'll be right back.
They want to chant down Babylon and burn down the whole nation. But them operate the land wrong. I'm a say Republican and them a scratch man. Tell them I'm a libertarian. Them say we want to lose, but we want to win. Come round.
Justice and peace. Chant love rule this time.
How what we say?
Chant for our works.
I got me tell them.
Chant down by justice and chant for righteousness, chant for rules, chant for all words, chant for all.
None of them when me chant, when me see, say all man was created equally. Chant down Babylon and do it daily. And when night come, pray for everybody. So one by one, me have to chant them man. Me chant down Babylon because Babylon is wrong. The only right man.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Jim in Texas. Jim, just from talking to you,
yes,
the first thing you should do is go to logosradionetwork.com and find the banner for Jurisdictionary. That's a course by a lawyer for pro ses on how to handle their own case in court.
Yes, sir.
There's a whole lot of basic stuff you don't know. And it will be hard to bring you up to speed until you get some of this basic information. And I assure you, it's like $250 for Jurisdictionary, and it is way worth it. You know, when those lights come on in my rearview mirror, I do not get excited. I was recently at the Department of Public Safety, and I wanted a ID. They said, well, if you get an ID, you'll have to turn in your driver's license. I don't want to turn in my driver's license. I just want an ID. And they insisted I'd have to turn in my license. And they brought a DPS guy in, and he said, Mr. Kelton, if you get an ID, you won't be able to drive away from here today. I said, sure I can. There's my car out there. I'll just go jump in it, and I'll take off. Oh, no, I'll pull you over and write you a ticket. I leaned over the counter, and I said, if you write me a traffic citation, I will give you a romp through the legal system you are not going to believe. And I meant exactly what I said. You want to play hardball with me, Bubba? I've been through Jurisdictionary. We will dance and you won't like it. If you had been through Jurisdictionary, the things that you're complaining about with your lawyer wouldn't have happened. Now, did your wife give notice of intent to appeal?
Yes, sir. And their response was, well, we figured that.
That's okay. That's not a response. That's just a smart aleck remark.
Right.
Okay.
Sure.
Now we back up and begin to sharpshoot them. One of the issues you bring on appeal is insufficient representation of counsel. That will almost always, if you can show that counsel acted in concert collusion with the prosecution in order to ensure that your wife did not have grounds for appeal. That's normally what court-appointed counsel does. Then this will almost get you back to the trial court. Jeff in Mississippi, who was on earlier, he got a new trial for exactly that reason. But I will make time early in the week to go down and have a look at the records in Weatherford. They know me there. Judge Buckner specifically knows me.
That kind of seemed the case when they were talking about some of the stuff after some of the stuff that they put in there. It seemed the case when they said that she couldn't speak of radio shows and all kinds of stuff in this. So it was a motion of limine.
Motion to remind. You mean remand?
Limine.
Oh, motion in limine.
Yes, sir.
You couldn't speak at radio stations. I want to see that motion in limine. It may be because they know me. Judge Buckner, I had a friend that was in there and he filed a habeas corpus. So I went down. Then they said told me they never heard the habeas. So I went down there and pulled the habeas out of the record. And then I asked the clerk, where's the return on the habeas? And she said she didn't know what I was talking about. I said, there's a habeas in the record. But there's evidence of hearings being held after the habeas was filed. But there's no return on the habeas. And she said, well, okay, so what? So what? The habeas is the great writ. Everything stands down before the writ. So when the habeas was filed, the court could do nothing until it heard the habeas. But I don't see any evidence where they heard the habeas. So they said, well, you need to go over to the court itself. So I went down and I was talking to a clerk in the court where the judge's court was, not in the county clerk's office. And this Guy come out in black shirt, black pants, short guy, white hair. And he's telling me that, I have to go get this from the county clerk. And I told him I was just at the county clerk. And the county clerk doesn't have it. So I came here to request it from here, and I have a written request for it. And he said, well, we don't have it, so we can't give it to you. And I said, that's okay. I'll give you the request, and you just give me a response that says we have no records responsive to your request. And then he said something that gave me a clue. And I said, wait a minute. Are you the judge in this case? And he said, well, yes, I am. I can't be talking to you. Oh, you can't? Well, why not? Well, I'm going to be filing criminal charges against you, so it would be inappropriate for me to be talking to you. And the look on his face was priceless. I left there and went straight to the district attorney's office and asked for a district attorney to take my criminal complaint against the judge, and they sent out these two guys with pistols. And I saw the pistols, and I said, are you guys ADAs, meaning assistant district attorneys? I said, no, we're investigators, and I don't need you. You're dismissed. I need an ADA. Well, what is your issue? I said, I have an issue that you don't have the authority to address. I need a district attorney so that I can make it known to a district attorney under Article 2.03 that a crime has been committed by Judge Buckner in violation of 3903 Penal Code, and you're in no position to take notice for the ADA. Well, you'll have to file it with us. I said, no, this is for the district attorney. Well, you're going to have to leave the building. And I said, well, Steve Whitaker's, I see that you got a pistol on your hip. Yes, I do. Tell me, is that pistol loaded? No, I just carry around an empty weapon. Don't get smart with me. If you got bullets in that pistol or not? He said, yes, he does. That's all I needed. And then they ordered me to leave the building and physically dragged me down the stairs, shoved me out the door. I got to my car and didn't have my keys. I went through their metal detector and picked up everything but my keys. And I come back to the door, and the bailiffs are looking out at me. And I tap, tap, tap on the door. It was open. It was unlocked. They come over and open the door. This older bailiff, he was kind of a fun guy. Well, Mr. Kelton, I see you're back. And he's grinning real big. He knows why I'm back. Yeah, this is a bit awkward here. Would you happen to know where my car keys are? And he held them up and jingled them. Yeah, as a matter of fact, I would. I got my keys. And in the parking lot, I called the sheriff's department, got a hold of the captain, and asked him to come down and arrest these two guys for first-degree felony aggravated assault. And he said, well, he wasn't going to arrest anybody. I said, well, you're a certified peace officer in the state of Texas? Yes, I am. So you're going to shield these guys from prosecution, violation 3805 Penal Code? Well, I'm not going to arrest them. That'll work for me, Bubba. So we'll be in touch. I hung up on him. Well, I really didn't want to get beat up and thrown in jail that day, so I went on home and started making up my complaints. And a few hours later, I got a call from this guy, and he said, what did you do? I said, why? Man, they dragged me into court and then couldn't get me out of Parker County fast enough. So, and I had hammered them a time or two before, so they knew me real well. I will go down there early in the week and have a look at the record myself, but you need to find out who the court reporter was.
Yes, sir.
And send a letter to the court reporter and request a transcript of the case. What may get this overturned and may get your wife out is when they realize that you've got somebody helping you to sharpshoot them. You want to request go to the State Bar Association and request any bar grievances filed against your attorney.
Already done. Oh, no, never mind. I apologize. I talked to him today, but I didn't request that. She ended up not having an attorney and doing it herself.
Okay. Did she?
She was going to just play Angry Birds anyway, so she said she wouldn't want somebody that would just play Angry Birds helping her. It wouldn't help her anyway.
Okay, that was a mistake. But she did fire the attorney before the final hearing.
She never hired the attorney. We've got it on
No. Listen. Stop. Was she appointed counsel?
Yes, sir. And about 10 minutes later, after he threatened her, she said that you are not going to represent me.
Okay. That'll work.
And I've got it on tape.
Okay, you understand. He was hired when he was appointed.
Yeah, okay, sir.
And he was under contract. He was under contract with the state, but your wife was the intended third-party beneficiary of that contract.
Yes.
So he was counsel, and because of his behavior, she fired him as counsel.
Yes, sir.
She should have asked for another counsel, but you didn't know that yet. And this gives you an effective claim for denial of adequate counsel. Now, first thing to do is go after this lawyer big time. Have you bar grieved him yet?
Have I say no? I talked to the criminal division of the bar association for the state, and they're supposed to be sending me some paperwork to fill it out. I talked to an investigator today.
Okay, we're about to go to break. When we come back, we'll talk about bar grievances and how if you file a bar grievance against this lawyer, the state bar will get that grievance and throw it in the trash. And that's a good thing. And when we come back, I'll explain why. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Jim in Texas. Okay, Jim, I'm going to go through some of the basics.
Yes, sir.
Best if you get jurisdictionary, and both you and your wife go through it when we get her out of there. Is she in jail now?
Yes, sir. She's been in jail since Monday afternoon.
Okay. We start with jurisdictionary. That will give you a good overview of how things are supposed to work.
Yes, sir.
The thing that makes them crazy and has the greatest effect is when you begin to sharpshoot them. There are some rules. Never give public officials legal advice. It is a natural tendency when you know you have rights and someone is violating one of your rights to give them fair warning and notice that they're violating your rights. Well, that's civil behavior. Well, this is not the civil arena. This is the legal arena. And there are a different set of rules here. In the legal arena, bushwhack is the name of the game. In that vein, never ask a public official to do anything you actually want him to do.
Kind of like asking him for his oath of office, and he leaned over the bench and told her no.
Oh, wonderful.
Yes, he did.
I'll go down and ask him for his oath of office.
And just said no. Right there on the record.
Okay, that's why you need the transcript. The transcript will, when you ask for a transcript, they're going to get real tense. And if you get any nonsense from the court reporter,
yes, sir,
then you immediately file a complaint against her with the governing agency for court reporters. Now, if you file a bar grievance against an attorney, the bar will get that grievance and throw it in the trash, and I'll get to that in a second. But if you file a complaint against a court reporter, their oversight agency will hook in gear immediately. And that court reporter will be really, really unhappy. We had one in the family court recently where the woman's trying to get a transcript, the court reporter's dragging her feet. They filed a complaint. She had to go down to Austin and appear before a board. And the board would give a recommendation. If she did not agree with the recommendation of the board, she would have to face criminal prosecution. That was a big deal. And they wound up with the court reporter throwing the district attorney under the bus. Oh, it was glorious. Okay. We request the transcript from the court reporter. And then I'll give you some written requests, and actually they will recognize the form of my request. Yes. Well, go to jurisimprudence.com.
Jurisimprudence.
That's Juris. Oh. No, I'm talking about Jurisimprudence, my site. Now, Jurisdictionary, you go to click on the link on the website.
Yeah.
Everybody listening should go through Jurisdictionary. Jurisdictionary teaches the stuff they don't teach lawyers in college, in law school. In law school, they teach lawyers how to argue legal issues. They don't teach them how to file motions, how to get motions put on for hearing, when to file certain kinds of motions, when not to. All this stuff that is the practice of law. They don't teach that stuff in law school because all the jurisdictions are somewhat slightly different. And rather than teach all that, they expect that when the lawyer gets out, for the most part, he'll be picked up by a law firm, and the law firm will teach him all this stuff. Well, they don't teach it. And the lawyers, for the most part, have to learn it once they get out. But it's the same thing you'll find in jurisdictionary. How to file motions, when to file motions, what kind of motions or pleadings to file, all this technical stuff. Somebody, if I get a caller who's been through jurisdictionary, takes no time at all that I know of. Had Mark out of Wisconsin, his son got arrested in a car with some other guys over some dope they found in the console. It wasn't his car. They charged him with the dope. I said, did you file for the habeas corpus? I did that. Did they hear the habeas corpus? No, they didn't. Did you file for a mandamus? I did that. Everything I suggested he should do, he already did. Because he went through jurisdictionary. Now he's got a good basic understanding of how all this should go. Yeah. Then we go back and look at what they actually did. When they arrested your wife, did they take her directly to the nearest magistrate, or did they take her directly to jail?
No, they took her directly to jail, and she was demanding the magistrate.
Wonderful. Good for her. Okay. When she was brought before a judge at the jail, did the judge have in his hand, when she first saw the judge, a document, a folder with information about her in that document, in that folder?
Not that I know of. I know that that's where he did her bail and read her rights.
No, hold on. Listen. I'm asking real specific questions.
I do not know the answer to that question.
Okay. When a person is brought before a magistrate can do three things in Texas. Magistrate can marry people, but that's so they can make a few extra bucks.
Yes, sir.
They can hold an examining trial and set bail. That's what they can do.
Yes, sir.
Okay, this one set bail. But in order to set bail, they have to make a determination of probable cause first, and they do that by holding an examining trial. And they hold an examining trial under Chapter 16, Texas Code of Criminal Procedure. There's a whole bunch of stuff they're supposed to do. And the first, right up early in Chapter 16, I think 1604, states that the rules of evidence apply in a magistrate court. So if you go to court, like when you went into the trial here, if either party has something to present to the court, they offer it in open court. And opposing party has opportunity to look at it and raise an objection. So the last time I was arrested in Williamson County, when I tried to get them to arrest a prosecutor and a judge, they brought me before this magistrate, and I said to the magistrate, Your Honor, I see that you have a folder there in front of you. Does that folder have information about me in it? He said, Yes, Mr. Kelton, it does. Tell me, Judge, where did you get that? And he got real tense because he knew exactly what I was asking. How did that evidence get presented to the court without me having an opportunity to object to it? It appears not to have been presented in accordance with the rules of evidence. And he knew exactly where I was going.
Yes, sir.
They couldn't get me out of there fast enough. The way you take these guys on is on the details of code. And before you take them on details of code, you want to sharpshoot them. You start asking them for records so that they will say, why is he asking for this? But don't ever tell them. And when you go in and ask a public official to do something, they are going to not want to do it. Never, ever let that upset you. Because you never ask a public official to do anything you actually want him to do. Because you never ask a public official to do anything that the law does not require him to do. And when he doesn't do what the law requires him to do, whatever you do, don't tell him. Because if you tell him, he might do it. If he doesn't do it and you don't tell him, then you go to a magistrate and file criminal charges of criminal violation 39.03 Texas Penal Code, official oppression, in that he failed to perform a duty he was required to perform, and in the process denied you the full free access to enjoyment right. You want him arrested. That is so much fun. You will not believe it. Hang on. We're about to go to break. When I come back, I'll go directly to bar grievances. One of the most powerful things you can do to a lawyer is file a bar grievance, whether he's a prosecutor or defense counsel. The state bar will get that bar grievance and throw it in the trash, and that is a really, really good thing. And this time when I come back, I'll actually go directly to it and state why that's a good thing. Randy Kelton, Rule Law Radio. Our call-in number 512-646-1984. We'll be right back.
Fake tanning is marketed as a safe way to get that healthy glow without spending time in the sun. But it's actually not so safe after all. I'm Dr. Catherine Albrecht, back in a moment with the dark side of spray-on tans and self-tanning lotions.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Americans spend millions on fake tanning products for that sun-kissed look, but are they safe? No. The active ingredient is typically a chemical called dihydroxyacetone, or DHA, that works by producing free radicals to darken the skin like an apple when it's cut. Scientists say DHA disrupts the normal cell cycle, causes genetic damage, and accelerates cell death. What's more, self-tanners often contain coumarin and ethylparaben, chemicals linked with cancer that can kill skin cells and cause reproductive harm. So spend 20 minutes in the sun instead and leave that fake stuff on the shelf. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, who you want to chip? Who you take me for? Free Dolly? Who you want chip? Me no free Dolly. You can't chip me. What I'm saying? Don't let them chip you in the morning, chip you in the evening, put a chip in your body. And then when you go computer reading, you can't.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're talking to Jim in Texas. Okay, Jim.
Yes, sir.
Bar grievance. If you file a bar grievance with the State Bar of Texas, makes no difference what you accuse the lawyer of, you will get a letter back from the State Bar of Texas saying that we examined into your accusation and find it does not rise to the level of misconduct. If you're accusing him of pushing a pickup load of dead babies off a cliff, they're going to send you that same computer-generated letter no matter what. That's what the bar does. The bar is not there. They're supposed to be there to police lawyers, but they're really there as a public relations agency for the lawyers. And that's a good thing. And the reason it's a good thing is their insurance carrier knows they're going to throw every bar grievance in the trash. So how do they gauge their level of risk? By valid bar grievances? Heck, they throw them all in the trash. By the numbers. One bar grievance your first year in practice, they will cancel immediately. 2 bar grievances any 1 year of practice. If you've been practicing 20 years, they'll cancel. 3, they'll cancel your law firm's malpractice insurance. Consider this. You get a new car, you go down to Walmart, you go in, you come out, somebody's backed into it and bashed in a fender. You call the insurance company, they fix it, they bump your rates. You go back next month, you come out, somebody's backed in another fender. They come out, not your fault, you didn't have anything to do with it. They come out, they fix it, they cancel. Your fault, their fault, nobody's fault, they don't care. You are an unacceptable risk. I had a lawyer tell me that is patently unfair, and I'm standing there grinning from ear to ear. And he said, ooh, I shouldn't have told you that. I said, no, you should not. You bar grieve your attorney. If he's been practicing a while, they'll double his malpractice insurance. And it generally starts about $25,000 a year. You bar grieve him a second time, they'll cancel. Then he has to go back and try to reset malpractice insurance. If you bar grieve the attorney, he has to notify his insurance carrier. He's got to tell on himself, because if he doesn't and you sue him for malpractice, he's not covered. So, okay, guys, you want to play hardball? Well, we introduce you to the deep end of the pool, the judge. The judge has a bond. It's actually an insurance policy. And you file a judicial conduct complaint against the judge, and the State Commission on Judicial Conduct is just like the bar. They're going to do everything they can to protect him. They will never sanction a judge no matter what he does, unless he makes some high-level public official or person with a lot of political clout mad at him. And politics are getting judge sanctioned. Almost nothing else. Judges can do anything they want to, and there is no oversight. Except for their bond carrier. If the judge can't get bonded, that's a requirement of holding the position. Every time he gets a judicial conduct complaint, his bond rating goes up. Makes no difference what the complaint is. Now, if you file a bar grievance, they are not going to say a word to you about it. Mm-hmm. If they do say a word to you about it, you bar grieve them for that. They're forbidden.
Yeah, I complained about the assistant county attorney with the county attorney. That didn't go very far.
Okay, so never, ever give fair warning.
Yes, sir.
They will treat that as a threat. Better if you set them up. One of the most powerful things I've done in Tarrant County is I went into court. A friend of mine was having a hearing, and I stood up at the bar. And this judge had thrown David in jail a couple of times. He was a real stinker. He looked up at me and he said, "Can I help you?" "Yes, Your Honor. My name's Randall Kelton. I have a hearing deficiency." "Well, Mr. Kelton, just what's wrong with your hearing?" "Oh, Judge, I was down in Mexico the other day, and I drank too much of that cheap tequila and lost my hearing aid." Well, I was lying to him. I had it in my pocket. "Well, why are you telling me this?" I said, "Well, do you have accommodation with the hearing impaired?" "No, Mr. Kelton, I do not." "I see you have sound system here. Will you turn it up?" "No, I will not." "Well, then will you speak up?" And he did. Told the bailiff if I didn't sit down, "Shut up." He's thrown me out of the courtroom. So I had my hearing, and when I was done, I walked to the bar and I pointed to the bailiff, "You come with me." We get outside, and the bailiff said, "Mr. Kelton, what can I do for you?" "I need you to arrest the judge." "Well, why would I arrest the judge?" "Class A misdemeanor, official oppression, criminal violation 3903 Penal Code, in that he failed to perform a duty he was required to perform and in the process denied me and the full and free access to your enjoyment of right." And the bailiff said, "Well, Mr. Kelton, what right did he deny you in?" "He denied me in my right to accommodation under the Americans with Disabilities Act." The bailiff said, "Well, Mr. Kelton, why didn't you tell the judge about the Americans with Disabilities Act?" Heck, if I'd have done that, he might have turned the sound up.
That's right.
And the bailiff stood there a minute, and this grin came across his face. He said, "Well, you set him up." I said, "Yeah, he was a sucker for that one, wasn't he?" That has had more effect on these judges and justices of the peace in Tarrant and Dallas County than about anything else I've done. Now the word is, if that no good, rotten scoundrel, Randall Kelton, comes into your courtroom, he is setting you up. They are right. If he goes to any public official and asks them for anything, he's setting you up. And that's right, I am. So don't screw with me. I went to Arlington 2 days ago, city of Arlington, and asked the security guard, cop sitting there at the front, where do I go to look at criminal files? He said, the police department. No. You're telling me that this court doesn't keep its own files? Well, we only keep tickets. Those are criminal. Where do I go to see those? He said, well, are these your tickets? I said, no. Are you an attorney? No. Well, then you can't look at those. Say what? Oh, you can't look at other people's criminal cases. Do you have a supervisor? Yes, I do. Get it. Well, what do you need a supervisor for? I need a supervisor to arrest you. Huh? Just get the supervisor. So he calls the supervisor. Supervisor comes out and says, what can I do for you? I need you to arrest him. Well, why would I arrest him? Well, I say misdemeanor, official oppression, criminal violation 3903 Penal Code, in that he failed to perform the duty he was required to perform, or he exerted or purported to exert an authority he did not expressly have, and in the process denied me the full and free access to enjoyment right. Well, what right did he deny you in? He denied me in my right to a public court. And the officer's sitting there, he ain't believing what's going on here. I didn't tell him that I can see these if I want to. The law says I got a right to this, blah, blah, blah. I didn't do all of that. I called somebody else and asked him to take the complaint. Well, this guy, he don't want to take the complaint. He said, well, I can't take this. You'll have to call Internal Affairs. No. Look at this guy. All the buttons are on his uniform. His uniform's not dirty. He didn't use any foul language. I don't have a professional complaint. Well, then what's your problem? I have a criminal accusation, and I need you to take that criminal accusation. Are you a certified peace officer? So yes, I am. Under 2.13 Texas Code of Criminal Procedure, you have a duty to enforce law. I make it known to you that a crime has been committed. I need you to do your job. Well, I'm not going to take a complaint. Oh, Okay, so you're going to shield him from prosecution in violation of 3805 Penal Code. That'll work for me. I need you to get your supervisor. Oh, this is so much fun, you won't believe it. Actually, it's too much fun. You get to like it way too much. But you'll also get to where they do not want anything to do with you. They want your wife out of that jail as fast as they can get her out of there. And they won't ever want her cited again. We have Scott Richardson who calls in on occasion, and that's what his position is. They don't want anything to do with him. Hang on. Randy Kelton, Rule of Law Radio. When we come back, I will try to kind of step through some of the steps you need to take. And since it's our last segment, so you kind of understand how to handle this. We'll be right back.
Easy.
Whoa. Oh, man. You in jail. You got busted up? Oh, man. I'm broke, dude. Some things in this world I'll never understand. Some things
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Jim in Texas. Okay. First thing, Jim, I'll come down there early next week, but you got to agree to one thing.
Whatever you need.
If they throw me in jail, you got to bail me out.
Okay, sir.
Went down with Deborah. She's here in the background. We went down to Williamson County, and she took my car keys away from me. That was a good thing. That way, all of them could get home when I got thrown in jail.
Yes, sir.
It happens on occasion. Not so often anymore because I've gotten better at it. These rules I've been giving you, I follow these rules, and they realize real fast that somebody's setting them up. And when they get somebody sharpshooting them, then they want this gone. Now, I have a challenge to subject matter jurisdiction. A challenge to subject matter jurisdiction can be filed at any time, no matter how remote in history. Before that, question: was your wife driving a commercial vehicle, a dump truck, or
no?
Was she hauling, transporting people for hire?
No.
Is there any evidence in the record that would establish reasonable, probable cause to believe that your wife was acting in commerce?
Absolutely not. As a matter of fact, she filed a affidavit saying that she wasn't.
Oh, wonderful. I like it when people do the right things. Okay. Did you request the certification of the peace officer to act in the capacity of a police officer?
On the traffic stop?
Yeah.
Well, we told him we weren't involved in commerce, and then he basically told us.
Okay, now hold on. Okay.
Anyway.
One of the things you got to get good at,
yes, sir,
is answering a question with laser focus.
Yes, sir.
When you go in and start hammering these guys, never volunteer anything. Unless you're volunteering something specifically for the purpose of having it said to somebody else. I was just at my courthouse, and I saw a sergeant there that I knew. Hello, Mr. Calton, how are things going? I said, oh, they're going great. And he had on a green uniform. Sergeant Ellis, I see they've transferred you to animal control. And he looked down at his uniform. And he gave me this wry smile because he knows I got a comment. So that means that you got promoted. You're out there picking up dead cats and skunks off the highway now. No, Mr. Kelton, I'm not in animal control yet. And then he said, what are you doing down here? I said, I'm down here filing first-degree felony aggravated assault charges against the district judge. Well, why are you doing that? He was a patsy. He set himself up for it. Well, the bailiff was standing right next to him. And I said that for the benefit of the bailiff. Because the bailiff is going to go tell the judge that I considered him a patsy and that he set himself up so that I could promote my personal agenda. That's exactly what I did. And he was a patsy. And the reason I did that is when I come back in there, I only want to have a fight with this judge if I pick one with him. I don't want him starting any crapola with me. So now he knows that if he starts any crap with me, I'll roll over him like a steamroller and have no compunction about ruining his career. Okay. So never give them legal advice. Never give them fair warning. They don't deserve it. You want them to think you're setting them up. When you go down and ask for records, and this is where you really start stinging them, is you ask for records in such a way that they won't know what you're looking for. Here's the deal. The more corrupt a jurisdiction is, the more frightened they are. Williamson County, Texas is well known as the most corrupt county in the state. Now, everywhere I go, everybody says, oh, my county is the most corrupt county in the nation. Everybody says it. But in Williamson County, it really was the most corrupt. Alex Jones won't drive through Williamson County. So I'm down there, and I asked to see this guy's file. I went down there with him and told him, don't tell anybody I'm with you. So I go up to he's going to see the prosecuting attorney. I go see the clerk. I want to see this file. And they go pull it out. And I look in it, and I said, where's the criminal complaint? I don't see it in here. Well, this is all we get. Now, wait a minute. I want to see the sealed envelope that you received this in from the justice of the peace, or from the magistrate. And he said, I don't know what you're talking about. Get somebody who does. Oh, well, I'll get my supervisor. Thank you. Supervisor comes, and I ask, where is the sealed envelope in which you received all this information from the magistrate? Well, we didn't receive it from the magistrate. Well, who did you get it from? Well, we got this from the prosecuting attorney. Ooh, where's the criminal complaint? I don't see it in here. Well, we don't get those. How on earth do you initiate a criminal prosecution without a probable cause determination from a magistrate in a criminal complaint? Well, this is how we do it. I think we're done here. So I leave. I go over to this county attorney's office and give them an information request for these records. I won't spend all the time going into precisely how I did it, but they had no idea what I was asking for. I asked for all the records collected, assembled, and maintained by the department that are specifically referenced by Article 17.30 Code of Criminal Procedure. That's the article that tells a magistrate after an examining trial to seal all the documents had in the hearing cause the name to be written across the seal of the envelope forwarded to the clerk of the court of jurisdiction. That's what I was asking the clerk for. They didn't have it. Said the prosecutor would have it. The prosecutor said they didn't know what I was talking about. Well, don't ask me. Ask the legislature. I didn't write the code. They did. Then I went and sat in a courtroom and was just taking notes and writing out what went on. And they sent this young prosecutor comes over and he said, sir. And I looked up and said, yes. Do you have a case in this court today? No. I go back to writing. He stands there a minute. Sir. And I look up, yes. Do you have a civil case in this court? Oh, no, nothing like that. I go back to writing, ignore him. He stands there a minute, and then he said, sir, and I look up at him, held up both hands with my palms out, no more questions. And you'd have thought I slapped him. He was stunned, and I went back to writing, just ignored him. And a little while he went away, and then an older guy, after a few minutes, came and leaned over the bar and said, sir, I'm the county attorney. Is there something I can do to help you? First, he told me where I could get a docket. I'd asked for an appearance docket. He said, you can get one downstairs at the clerk. I know, the bailiff told me that. Thank you. And I go back to writing. He says, sir. I said, is there something I can do for you? I looked up and said, if I need you, I will summon you. Until then, you're dismissed. And I go back to writing. He's never had somebody dismiss him in his own court before. So we leave, and Doug, the guy who was arrested for 2 prescription pills in an aspirin bottle, that he brought him the prescription, they're still prosecuting. They dismissed his case, took him to a judge and had a judge sign the dismissal order right in front of him, took him down to the clerk, and the clerk filled out the paperwork to get his bond money back. He got it the next day. He came to a seminar I was doing at Brave New Books, and he said, you ever walked in a room and turned the lights on and watched the cockroaches scatter? He said, that's what it looked like. What happened was they had no idea who I was, and I never told them. The more corrupt they are, the bigger and deeper and darker the skeleton they got in their closet, the more they're certain I know what it is. They're going to run home and tweak that closet open, look at that skeleton in there, and they know that that's why I'm there. The more corrupt they are, the more afraid they'll be. When you don't do what everybody else does. And this is how you do that. When you walk into the courthouse or a public building, you need to understand you're the baddest motor scooter in the building.
Absolutely.
Yeah. And the reason you're the baddest motor scooter in the building is you are nobody. You're not a judge. You're not a prosecutor, bailiff, court clerk. All of these people are public servants. They're the servants. You're the master, and they are not to forget it. They forget it at their professional peril. And once they understand that you are the master, and you're down there to ensure that they follow your law, and you don't care what they think about it, everything changes. They will want your wife out of there. They don't ever want to see her again. I was in jail, convicted to a year in prison, $10,000 fine. After 24 days in solitary confinement, I filed a whole bunch of criminal complaints against the judge and the prosecutor and the bailiff. 2 days I was out. They wanted, and they already had a conviction on me. 2 days I was out of there. So this is a short. We only have 2 hours today. We can go into more detail tomorrow. And this is how to run the routine on them. And if you want to call back tomorrow, I'll go through how to run the routine on these guys. Just set them up and start stacking up the charges against their professional careers. So they will want your wife out of there and won't ever allow her to get a ticket again. Okay, thank you all for listening. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. We'll be back tomorrow night on our Friday night 4-hour info marathon. Thank you all for listening, and good night.